Martijn Snoep, Fiona Morton, Philip Marsden. Very warm welcome to the Digital Markets Research Hub. It's a great pleasure to see you. And today we will be discussing a topic which is one of the central for the new emerging regimes for tailoring competition in digital markets, and which somehow we have a good reason, because very recently the Dutch Competition Authority, alongside with some national competition authorities, a few member states, significant part of them, and more specifically hosted by you, Martijn, and you, Fiona, you have co-organized a conference in the Netherlands with the focus on business users. And this moves me perfectly to the kind of the spirit of this of the new regimes. I use plural because we have in the UK a similar one. And your ideas, Philip, or maybe the ideas which you have channeled so vocally and so convincingly to the traditional competition law people about the participative approach. So business users know, sense, understand best the trend, the dynamic, the spirit of competition, and listening them is very important. So, but it obviously has some side effects, some significant advantages. And it will be hard to find people who know and can inform us better than three of you. So I propose, let us start with kind of more introductory question, and starting with you, Martijn. How do you see the role of business users in this new emerging regime?
Well, the business users are extremely important, and it's in a way it's not that different as they are important in an antitrust investigation or in a merger investigation. Is you need business users, you need complainants, you need people as an authority for who you actually do the work. And because for two reasons, they provide, first of all, they provide the necessary information to bridge the information gap that's between the agency and, the emerging parties, or between with the gatekeepers or whoever it is that is under investigation. And second, they provide, I would say, kind of the fuel for the investigation. If you have no one for whom you are fighting, you're not a good fighter. So that's why. So it's most information, but also, which is more kind of maybe esoteric, energy, drive, purpose for who you do the work.
Thank you very much, Martijn. Fiona, how would you expand this?
I agree with everything Martijn just said. In particular, the DMA has an element to it that makes the business user disproportionately important for that regulation compared to others, because it requires effective compliance. The gatekeeper has to be complying in an effective way, not just a box ticking way. So I have done A, B, C, D, and yet a business user cannot get onto the platform. That means A, B, C, D are not sufficient. They're not achieving the compliance that the law demands. So that means that to enforce that kind of a rule, the regulator has to understand what getting onto the platform entails. And where would you learn that? You would learn that from the business user. So the business user really has to try out the compliance offered by the gatekeeper, A, B, C, D, and find out if it works. And if it doesn't work, then come and tell the regulator or their national competition authority, if they're more comfortable in that language, visiting nearby, so that the regulator can understand what's not working.
Thanks a lot, Philip.
I was so impressed by the meeting that Fiona and Martijn hosted at the authority. It got so many people's attention, primarily because it was an ECN-related DMA event, which shows that the authorities are interested, and they're perhaps accepting the fact that this kind of participative dialogue amongst various parties, rather than an adversarial litigious point of view, is something that's helpful. I remember when we, in our banking inquiry, which I know I talk about too much at the CMA, we introduced open three-party hearings, and it just was more efficient to have the complainants, whatever, in the room saying, no, we can't interoperate with that, or no, that's not possible for this technical reason. And then the other side would say, well, we can maybe work with you, but they would say something. Whereas if it had been one-on-one hearings, adversarial approach, we'd been doing this for 2 years, it was he said, she said about whether it's not effective. So to have as many participants in the room from a business point of view, I think is very helpful. We can talk later perhaps about whether in an actual hearing or something, it's helpful to have civil society or others. But perfectly, I think to start off the actual question, is there a problem? What would be various solutions? I think it's an excellent approach, and I think it was fantastic. The only thing I'm happier about than the meeting at the Dutch authority was the fact that one day after our legislation passed in the UK, the CMA introduced its guidance, or draft guidance, and I thought that was quite impressive and shows that the CMA had been working behind the scenes, as we all know, for many months, and that was very good to see as well, which gives guidance to both sides of the transaction.
Absolutely, and this comparative elements. We often in academia hear comparison as kind of buzzwords doing for box ticking purposes. Here we have a genuinely fertile soil for comparative analysis between two twin regimes or sister regimes, sibling regimes, informing, feeding each other, cross-checking, etc. And one of the systemic features of both regimes is this participative approach, and it has several different trajectories. So it's not like synonyms, with very different settings, I imagine. So, and the central one is the communication with gatekeepers, but also communication with business users, communication with national competition authorities, communication with potential newcomers, with end users at some point or their representatives. So how would you visualize this map this relationship between different stakeholders within this new regime, Martijn?
Yeah, I hope that, and I see this. So directly after the DMA conference, we were approached by a number of business users who we wouldn't have been in contact with without the conference. So I think that was a direct result of the conference. And now it is important to keep the momentum because these things, you have a summer, lots of political events and other stuff, and then maybe there is a disappointment and then everyone moves on and goes back to the way they worked before. So I think it's important for all of us, for the ECN community and the DMA community, to keep this debate alive and to follow up and go to the next stage. And that's also what we intend to do. We're also discussing follow-up the conference with on the DMA conference that we held. See what the appropriate format would be, because we don't want to exactly replicate what's going on, because a year from now I hope we are in a different stage, so we need to do something different as well. But to keep that dialogue with the business users going is very important.
It would be great to have a similar format in a different country with a different mix of countries and entrepreneurs. I do think that this is still getting going. There are entrepreneurs forming businesses, being inspired, realizing what they can do, and that having another event in a different place that therefore attracts different kinds of business users would be really, really good. But we need a national competition authority to be inspired and decide that they want to take the lead on that. And I'm sure everybody on this call would be happy to help them and talk to them and so forth. But I also agree with Martijn that the next thing that the Dutch Competition Authority does, or this group that did this first event, should respond to events in the next year and think about what the problems are likely to be next June and what people are going to need to hear about and be inspired about next June.
Thanks, Fiona. Philip?
I was just going to say that as Martijn started with, I mean, there's all this hand-wringing about the digital legislation from various sides. Many years has been gone by since this hand-wringing started. And I was always surprised, because the merger control is pro-competitive ex-ante regulation, which lawyers were able to adjust themselves to a couple of decades ago and work out how to become extremely good advisors in this area and build careers, etc. And so I don't really see it very much different than that. If the party wants to do something and it may be questionable under the ex-ante digital regulation, they have an incentive to engage with the authority a bit more positively than if it was an antitrust ex-post investigation. So this is just all obvious stuff that people would say. But the hand-wringing that I found most odd was I've heard two complaints about this participative approach. One which I hear a lot, though they blocked me on Twitter, is this is just chat. This is just everybody is sitting around having a chat and slapping themselves on the back, and you've got to do something. Right. Well, things come from these things. It's a discovery exercise in the first place. You need to find out what kind of problems are going on. Are they legitimate? Are there solutions that require regulation? Are they perhaps something else that could be done commercially? But the thing is that then on the other side, I hear this hand wringing or see this hand wringing about, well, there's no due process in participative hearings, and there's no, everything's going to end up in court anyway. So why do we bother? And I understand that as well, but frankly, the democratically elected governments have chosen this approach. A key part of it in having ex-ante regulation is a kind of a discovery exercise, a compliance exercise, supervision and enforcement. And so for me, I just see these aspects of it as only beneficial, and it'll be up to the authorities themselves to make sure that it doesn't descend into some chat, as one critic in particular has said. On the other side, that it doesn't violate any kind of due process, and where it's a discovery exercise, it is, and it's public, etc. And when it's an actual case-related case, the doors are closed a bit more, but you still have these multiple voices. And remember, the main goal for this, at least from the UK point of view, was a prior that said, in this kind of world, we need a diversity of innovative challengers. We're not going to pick numbers of challengers. We just want a diversity of views. And so this kind of thing it requires more voices in the room. Obviously, there's a diversity of views that are unmanageable and perhaps not relevant. And then there's others that are, but we want to get away from this shouting match as we have in ex post regulation, ex post enforcement, which is perfectly legitimate. Make your best case to the court. They make their best case and the court decides, whatever. But this is something much more which requires preparation, and I applaud any authority that gets involved in this. I don't see any huge risk to it from a case perspective. It's only something that would be very wise. And I imagine another thing that the authorities will probably think of doing is having workshops like the European Commission did, which were more technical. And I applaud those as well, where you actually get the technicians in the room, the lawyers and the economists, but especially the technicians who can say, well, that remedy didn't work in Australia for this reason, or that remedy worked very well in Holland for this reason. And so you can learn from what doesn't work as well.
But I think what we're going to see is that even in traditional antitrust, you would see this kind of participatory dialogue, because this is something that we've been doing in the Netherlands already for quite a long time. Not solely. I mean, sometimes you need a stick. If there is a real bid rigging cartel, I mean, that is not a place for participatory dialogue. But in these complicated 102 cases, and I think the Commission's case against Apple in the access to the NFC chip is a good example of how you can use also antitrust in a way to reach solutions that have an immediate effect on access to business users, and where you can immediately measure whether it's successful or not, or whether it works, instead of going through litigation for decades. And then find out that the world has moved on and the problem wasn't solved.
Yeah, Oles, do you mind if I respond to that? Because I think actually that's quite a profound point, that having both 102 and the DMA changes the nature of your 102 participatory dialogue. I think it would be much more likely for Apple in this case to have decided to do that interminable legal process for 7 years if there weren't in the background also the DMA requiring access to the NFC chip. So you have two different instruments. If you're the government, the firm faces two different requirements to open up this piece of technology, and therefore it's just in their interest to figure out a way to do it that suits them, offer it, and then away we go, and we end both of these problems at the same time. And this is exactly what you want a DMA or a DMCC to do, to make things more reasonable, quicker. The firm realizes they just have to comply in some way, and then of course it's in their interest to find a way to comply that suits their technology and is not designed by a bureaucrat somewhere, but is actually picked to work for them. And it seems to me that that's definitely in their interest, and that makes the whole exercise much better for society.
But the NFC case is also an interesting example of how national authorities and the European Commission can work together, because in 2020 we started an general market study into the role of big tech in the payment markets, and one of the issues that we found was the problem with access to the NFC chip. Then we kind of, the DMA was still, well, in the making, under consideration. We had the interchange fee regulation, where there were kind of a little possibilities where we are the competent authority. The European Commission has no individual authority. And of course, we had 102. And then, so we decided to do an investigation into whether there would be a possible violation of the IFR, the interchange fee regulation, and found a year later, no, it's not. We cannot use the IFR. And then we said, okay, this is therefore a good case for a DMA and for ex-ante regulation, because it's a problem that needs to be solved. And in the meantime, the Commission had initiated a 102 investigation, to which we deferred and said, okay, we're not going to handle this individually. The European Commission is the best placed authority to do a 102 investigation. And I think this is, and comes back also to the role of the national competition authorities under the DMA. We are part of one team, together with the Commission and together with the national authorities. And particularly in this area of cooperation, testing, trying out few things, and then ultimately leave it to the best placed regulator, to the best placed authority to deal with this finally.
Based on this, let me ask you, from your experience, observation, intuition, does this new approach, which we call participatory, and which epitomized by the DMA, but as you just highlighted, Martijn, it was there already in one way or another. Does it require a new kind of basic enforcer skills at the level of case handler? Does it require a broader vision, so to say? Is it a sum of compliances, of individual compliances, or it should be somehow fed, be informed, steered, channeled by a broader, more holistic, as you feel it preferred recently, vision?
So I would like to say something about that. I think it is really interesting to me to watch, and the conference was very informative in this way, because an authority is naturally adversarial to the firms it's dealing with when you're talking about an antitrust case or a cartel case or even a merger case. The merging parties are the ones who are possibly breaking the law. Here, with this conference, you had a bunch of entrepreneurs who are all trying to get in to these markets. And the competition authority is not adverse to them at all. We're trying to understand what they need, whether the compliance of the platform is helping them, if there is some missing problem that can be solved by the regulator. So actually, the NCA and the local firms that are the business users are not adversarial almost entirely. Now, there's a little bit of, I want something that's good for me, and the gatekeeper doesn't want to give it to me, and it's not actually very useful for consumers or any other business user. That's a problem that the NCA doesn't want to be solving. They want to be choosing problems that are broadly helpful to all consumers and many business users. But still, in the main, they're working together. And I think that is a little bit of a new posture for an NCA. And you can correct me, Martijn, if that's not a correct feeling.
I agree. I think an additional skill that needs to be developed, but this is also generally about enforcement in the digital sector, where it's more prominent than anywhere else, is that I mean, the agencies, they're pretty self-centered and natural. They're part of a tribe, and we do the things that are for our tribe the best. And here I think that's also something that we discuss at the agency in the Netherlands quite often. We also need to think about other tribes and who is the best tribe to deal with it and share success with other tribes. So I think that's, in the UK, you have the Digital Cooperation Platform Forum or something like that. And as soon as I read about that, I immediately thought, oh, that's a great idea. We need to copy that in the Netherlands. So that's what we did. But you see the same thing here when we work together with the other regulators in the Netherlands is, everyone tend to be focused on its own job and its own work. And I think the important skill that we need to train our case handlers on is that they are part of a wider, if you want to say, ecosystem of enforcement. And that they have to also think about, if they do something, what is the effect for someone else, or has someone else better information position, is better placed to deal with a particular issue. And I think this cooperative spirit of enforcement is becoming more and more important.
Philip, I wanted to you on one hand, you've been continuously critical as a traditional competition lawyer about this injection or almost idiosyncratic about this injection of trade policy considerations into competition calculus. On the other hand, you talk about more holistic approach. So when we are in the closed room, I imagine, within this regulatory dialogue, is it about kind of trying to be kind of alternative dispute resolution, trying to find a happy medium between gatekeeper and business user? Or you are rather wearing a policy-making mandate, thinking of broader interests of society? How would you consider, and also based on your experience with financial regulator?
Okay, well, on FinServ and telecoms, for example, as you alluded to with the questions to the others, the thing that I find hilarious about is in the competition law silo, at least, is that the lawyers are still losing their minds about this brand new instrument. If they walk down their law firm corridor to the FinServ lawyers or the telecoms lawyers and explained what was happening in digital, they'd all say, yeah, okay, how can I help? We do this all the time. We look at problems of access to a network, or in FinServ, we look at insider dealing or self-preferencing. This is routine. We have a compliance mechanism. And usually I get criticism about this. I go, oh, it's very different. It's not telecoms regulation in digital. It's not financial services regulation. There you can't enter the market unless you're licensed, blah, blah, blah. I'm not making the point that the whole regime is exactly the same. I'm saying there are similarities. And if the lawyers can learn from each other, which I'm sure they're not bothering to do yet, but the regulators already are in the UK and in the Netherlands and other places. And so I don't want to get too much into the trade policy side because I'm supposed to be a great fan of the USTR right now, apparently. But my issue 25 years ago when I wrote that book was about a trade policy emphasis on breaking into new markets, entering new markets with the power of a trade representative behind it can actually distort efficient systems. And we saw this in the Kodak Fuji case and others. And that's why it was good that Kodak and the USTR lost that case at the WTO. Now, fast forward 25 years later, what I'm less interested in trade policy. But what I am happy about is the fact that trade representatives are actually speaking forward about these kinds of issues and how they could help, et cetera, whether from a remedial point of view or an analytical point of view, or even just advocacy. But the main thing I actually applaud them about is the fact that I think this trade policy initiative in the US, at least, stems from Biden's all of government approach. I think it is. I mean, obviously Fiona knows more, but I think that that's where you try to take all of these various instruments and say, how can we benefit more open markets, freer markets, fairer markets in different ways using different instruments? I think you have to be careful about choosing, say, 11 different instruments to have one particular problem. And I think that's why the digital markets legislation in various countries has been crafted in a way that we turn to that first, right? But we learn, I mean, the humans we need in these regulatory bodies now will probably have experience in FinServ and in telecoms and other cases. And that, I remember Thomas Cramler from the European Commission saying, we need to retrain everybody or hire them as regulators with that kind of thought process. Can't just have a, cartel investigator suddenly take over some of these cases. It's a completely different mindset, as Martijn says. So I just think it's something where there's a great opportunity for experimentation. We all know that the regulators are in silos as well. And so, as you say, it's and more opportunity for, even as we do in the UK, at least formalizing the cooperation, not through MOUs per se, as used to be done in the past, but actually forcing people into rooms together and saying, look, we've got this problem. And I mean, is there a privacy aspect we should be concerned about in terms of the remedy, or vice versa? And so, I think it's excellent to continue and emphasize this. I think solutions are going to be needed with input from other regulators, and I think that's not more chat. That's to find a better, more bespoke remedy that maintains the benefits of the innovation, but ensures there's a diversity of access so that you can find new products more readily rather than just looking at one.
And for the purposes of this regulatory dialogue, do you think you need to have a lot of competences? You have to have this ability to impose high fines and maybe even go to structural remedies, at least hypothetically, to use it as a bargaining instrument to to increase the power of
Not
the-
hypothetically.
Yeah,
That's all I
yeah.
correct
So
you on. Not
yeah,
hypothetically.
I think you really do need those. What we've seen in the case of the almost immediate non-compliance investigations by the commission is that there are gatekeepers who aren't complying. I mean, you don't open an investigation in 9 days unless you're pretty sure what's going on. And we see from the way, for example, that Apple has set up the core technology fee, that the design of that scheme actually blocks developers from using third-party app stores. So that's the opposite of contestability. That's trying to actually stop having any competitors. So when you have a firm that is refusing to participate in the regulatory dialogue and essentially just saying, no, I won't be regulated, there has to be some kind of backup tool that can be applied to stop that from happening. So a very large fine, structural remedies, etc. Of course, as an economist would say, this is off the equilibrium path behavior. This is not a direction anybody wants to go. You go in it because the gatekeeper is refusing to talk and come up with helpful solutions. If everybody's talking and coming up with helpful solutions, there's no need for very large fines and structural remedies. So I think it's very wise of the drafters of the law to put those in. And if they're maximally effective, we will never use them.
Yeah.
So that's the way you want to think about it. And it's unfortunate that we're starting out with one gatekeeper anyway, who seems bent on discovering if those provisions of the law will actually be enforced. But I think they will. I mean, many lawyers say to me, oh, judges don't like having high fines. Well, that's true, but judges also don't like it when firms say, I refuse to obey the law. I just don't feel like it. And that's not really how democracies function. You can't run a country that way. So I think judges appreciate that too.
There is also a feeling about the new system that you can, metaphorically speaking, by being so interventionist, it has only X amount of changes which you can make with this toolbox, and you can do it either in the targeted, surgical, precise way by a single enforcer, or kind of in a more dispersed way by the army of private litigants who would somehow, by sensing where the injustices are, by having capabilities to launch new case to private enforcement, is it a zero-sum game, so to say? Is there any risk of doing it too proactively on the private side? Would it diminish the competences of the Commission or CMA?
And I'm not entirely sure whether I fully understand, but let me try. So I think the role of private enforcement is hugely important, because it also leads to participation of the business users. It leads to kind of a more diverse discussion. But I think the biggest downside of private enforcement is that it takes even longer than public enforcement before you actually have a stable situation on what the norm is and what the law says. So I think they go hand in hand, public and private enforcement. But I think the great benefit of public enforcement is that you can set a compliance vision, compliance structure. You can fill in open norms with guidelines and therefore structure the debate. And that's something that private enforcement obviously cannot do. So I see a role for both of them, and they will strengthen each other in a way. But I think a world where there is only private enforcement, I think that will not allow for a fast enough development of the law.
But
Just a
private
quick thing on-
enforcement,
sorry.
because these markets are so complex and there's so many of them and so many different types of business users that might want to get in, I again think it's quite nice that the law has this private channel, because if the public regulator doesn't have time, overlooks, misses something, then the private side can swing into action and go after it. And hopefully by that time, the public enforcement has picked up and a judge can see, oh, my private case here actually fits with this public one that's farther advanced, and I will design a remedy that matches or something. And then that would actually create synergies among the different kinds of cases.
I think what's really important, and we see this in the CMA and other authorities, is that you try to take like a kind of a market investigation reference point of view, a market study type of view. You learn as much as you can about the market, you know, identify whether there's problems or not, and that informs you for a range of cases. It's no secret that authorities, even the market investigation people, when I was at the CMA, they're not completely siloed from others, you know, and information travels. It's no great secret, you know, and so it helps choose, as Martin said, a different option, different regulatory instrument, if that is appropriate and legally permitted or whatever, but also the idea that you've got a more higher information base. Far be it from me as a former prosecutor or litigator in my past life of saying that you don't get a lot of information from a legal case, you know, discovery, etc. You get lots. But what I find about private litigation is you can't rely on it wholly, as the others have said, because, you know, 90+% of them settle. So where's the guidance? You know, for the other businesses and etc. And in other cases will go all the way to the Supreme Court or the European Court of Justice, probably with a preliminary reference, which delays things even more. So wouldn't I say, it's great that some of the authorities have gone and done studies that will definitely inform their early cases. And that is, I think, a more acceptable approach. During the study, it's a more collaborative, participative approach from most parties. It's rare when a party will completely block a market investigation, not appear at it. Sometimes they can be compelled to appear at it, but it's much less likely to have something that's going to end up in an invisible settlement of a financial nature or an appeal all the way up. And so I just think that it's nice to have that, as Fiona says, but we can't rely on it wholly. And I just think that as was said earlier, the judges themselves will have a better information base as well if there's been some sort of preliminary work in the area that people can turn to, not just, you know, what this academic says over here and what that academic says over there, especially if they're paid academics.
Indeed. So let us move then to the workshop itself, and maybe you can highlight to us the motivation, which I think it became self-evident already based on the previous interventions. Maybe the main takeaways, the main contributions, the main surprises. Maybe did you see more or less equal spread of enthusiasm and diligence and depthness across all core platform services, or there are some visible or obvious discrepancies between the attention of the participants? All more general reflections about the event itself. Let's start again with you, Martin.
Well, I give the floor to Fiona. Fiona had a wonderful summary of the conference at the end of the conference, and I think that says it all.
Well, thank you. Martijn and I had this great train ride where we thought of this conference, and I was reflecting this morning, actually, before getting on this call, that I didn't do as good a job at the conference as I would have liked in following up that description of the idea with a little bit more of the purpose, which was at the time in the fall of 23, everybody, the narrative was being controlled by the gatekeepers, and it was a lot of moaning about how we're not going to be able to do things exactly the way we want. We're going to be constrained by regulation, and that will be terrible, and products will break, and we know best, and so forth. And nobody was talking about all the things that we might get, the upsides, the new entrants, the new ideas, the new varieties of products, the different flavors of services that competitors naturally introduce to a market. Moreover, at that time, there was also a lot of moaning about how Europe isn't innovative and we're falling behind and we're not as good as the United States. And I frankly just didn't believe that. But I also thought, well, how about we beat the bushes and find out who's here and what they have to say and what they're doing? And I think the conference showed that when the very competent Dutch Competition Authority goes out and looks for entrepreneurs, they are in fact there, and they come and they talk. And that was quite uplifting, I think, for everybody. And one of the things that's self-evident, I think, to consumers, but perhaps not to gatekeepers, is that there isn't just one solution to a problem. Apple or Google may say, here's the best, and fill in the blank. Map, store, search engine, whatever it is. But there's just a wide variety of tastes. I mean, look around among your friends. The number of different kinds of restaurants and ice cream flavors and shoes and travel services that they use is just extreme. And the idea that you want one party offering one flavor to everybody, we'll all eat vanilla forever, is just not, that's not attractive. We want this flowering of innovation and variety. So I think it's just very clear why this kind of law is needed to let those variety of competitors onto the platform. Anyway, Martijn, what did I leave out?
No, I think indeed, that's a great summary, and it's also something that we found. I mean, this is on the positive side. On the negative side, I think what came as a surprise to me was how reluctant the business users were to speak up. So, we really had to engage with a lot of business users to tell them, no, you really have to come. Because it's important that your voice is going to be heard, and most of the time says, yeah, but we are afraid about retaliation by the gatekeepers. We cannot do that. Maybe we can send our representative of the trade organization. And I said, no, we really want you, CEO, or really people at the top who are the business users. Yeah, can we send then our VP government affairs? No. You have to come. And I think I was surprised by that. I didn't and also shocked in a way. I didn't realize that so many companies were so afraid of the gatekeepers. And what they explained to me is that, which they said, it's a bit of gaslighting. So what happens is, if we don't know exactly. So it's just not this is not literal retaliation, but there is a new update, and suddenly our app is not functioning. And then we immediately think, maybe it was because we said something at this conference. And then we give a call to one of the gatekeepers and say, how come this is not working? Oh, yeah, we'll fix it. And then it takes longer than it normally takes. And that's, so we are constant, because we're so dependent on these gatekeepers, we are in constant fear that they somehow punish us if we do not talk their talk or walk their line. And I think that I was surprised hearing that from very senior business entrepreneurs of, not, big, not the biggest size companies, but moderate, medium-sized companies who were afraid of that. And I thought, other than more economical reasoning, I thought also that's not good in a democracy and in a society to have that type of fear. So I think that's we need to.
Not when you're asking for rights that are available to you under the law. I mean,
precisely. And I like Martin's point also about not relying on the trade associations. They provide great value in many ways, I'm sure. But the main thing is that the gatekeepers are funding many of these, not wholly, but therefore that means that if I ever read a trade association paper, which I'm trying to stop doing, frankly, you can tell that it's been mellowed, right? Probably because a bit of this fear,
Philip,
but also just the message itself has to be mellowed a bit for a trade association. And I think that's where you get less of a direct experience than if you have the actual players in the room. Sorry, Fiona.
No, 100% on inviting somebody to the conference. We did say at the end that one thing that the small business user can do if they're afraid is to make a trade association that shields individual companies. It enables them to learn what the common ground is, go collectively to the NCA, explain the problem. And I think, again, private litigation, a court is much more interested in what hundreds of businesses want together than a single one. So there's an upside to the trade association as a way to protect yourself. But I agree, not as a way to write papers or attend a conference.
And so we are in this experimental mode, and we try different techniques. Business users try different techniques to amplify their voice, to channel it to the right receptors, and also we understand that another significant, equally important category are challengers, those who are potential new and hypothetical new entrants. Their chances to increase their market share are next to zero, probably. The more entrenched these markets are, the less plausible it is. So probably two questions, micro questions in this regard. How should we accept, is it a positive inter-ecosystem competition where one core platform service, non-designated, of a gatekeeper designated to another service, uses DMA as a tool to amplify their interest and channel them to against other gatekeeper, and vice versa? And another one, what if smaller companies try to cooperate in order to maybe boycotting or somehow using some formally hostile measures vis-a-vis designated gatekeepers? Should traditional competition law be more lenient and less responsive to this formally anti-competitive behavior? Martijn.
Just a small point. It might be a micro point on your micro point. So there's a theory out there, not widely believed, called oligopoly competition. And so, of course, obviously, these gatekeepers do have a degree of oligopoly competition in the sense that they compete in different service areas against one another. Usually not on their main service provision, but with respect to other add-ons or even with respect to just advertising, whatever. But the thing is that they actually, in my view, collaborate or are reliant upon each other quite a bit, whether it's paying for data use or paying for the first on the screen, or the whole Safari Apple thing, or just board seats. We've seen these kind of things having to be let up, just that kind of investment in one another, and I think the authorities are rightly looking at that and saying, well, obviously we can't leave it completely to the market because we see what's happening without the legislation. But on the other hand, there's these other ways, in addition to gaslighting, where they're actually collaborating necessarily perhaps for everybody to sort of slightly degrade or not touch other people's work or something, as opposed to fighting for the kind of business that they might. And so these are just suspicions of mine when I see all of this collaboration or investment and things like that. I'm not necessarily inherently suspicious with that kind of stuff, but it's relevant, right? And so I think that's something where you have to look at that and say, no, actually, we're going to not tolerate that board seat. Removing somebody from board might not make any difference at all, frankly, but it's a sign, it's a signal. We're watching you and we're concerned about what might be happening in that space. And so that's why I think this oligopoly aspect is more in terms of let's have more regulation in this area, as opposed to let's sit back and let Robert Bork decide everything. Haha.
Yeah, I think the way, I mean, if gatekeepers enter each other's plantation, I think I'm kind of mixed about it. I don't know. On the one hand, I think I'm agnostic to any kind of competition as long as it's more competition. And on the other hand, I also see a huge danger. I mean, you see the same thing in the cloud market. We're dominated by Amazon and Microsoft, where Google is the third one out. Is it the challenger to the market? What happens if this becomes a duopoly and Google is part of basically an ecosystem that's even making barriers to entry higher, with the three of them sharing the revenues. So I don't know. I think probably the wisest thing is to look at it on a case-by-case basis. Start out with an agnostic view, but not a naive one, in the sense that you really have to look into, is this the type of competition that we want to stimulate, that we want to foster, or do we really want newcomers into the market?
I'll take another step in the agnostic direction. I'm actually a big fan of any competition of any kind in these markets where we have a dominant player. I am fine with Amazon coming into operating systems and handsets, and Microsoft into search, and Google into cloud. I think it's great. I do think, however, that you aren't naive. You know that if Google is paying Apple $20 billion a year for exclusive default search placement, that there's a relationship there that they're going to protect. But maybe the way to square that circle is to say, when we see Microsoft complaining about search, or Google complaining about cloud, or Amazon complaining about Android, that the way to respond is to adjust our regulation or bring a case in with an eye toward who else might want to come in? Can we establish a precedent or a set of rules or a procedure such that not only is the other big gatekeeper helped in entering, but anybody else would be helped in entering also, and that you don't do something where it's let them in and slam the door behind them, but rather bust open the door and keep it open so that others can come in as well. But I think we're in real trouble in a lot of these markets with one choice, and I'd rather have 2 or 3 than 1, even if it's a party that does other stuff. But we need to use them as leverage.
I mean, Fiona's point is very, very apt. I know that in the Dutch events, this idea of the plantation came up, and a while ago I talked about this idea of having these just massive, huge American fields, you know, like that, full of GMOs, and yes, you have bigger stakes in the US and cheaper this and cheaper that, and obviously under WTO rules we banned all that because we don't want that here. So we took this so-called prophylactic approach. Well, we're not doing that. We're not banning the tech giants from Europe, but we're saying we don't want this toxic waste. We don't want just you know, this one type of GMO grain. And of course, as Fiona said, I mean, we might be pleased with 3 or 4 other GMO firms competing for that field, you know, like that, but then you're only going to get GMO food, right? Fair enough. It depends what you democratically decided you want to eat, and what you care about in the environment and all that kind of thing. But she's absolutely right, of course, that if it's opened up to some, it has to be opened up to all. And that's where you get those lovely, nutritious new ideas, maybe even just on a part of the farm, an experimental part of the farm, which is what it always was. It always should have been an experimental part of a landscape where people are growing different things and things. Now you can't have that. You've got to toe the line with respect to the food and the water and other things that they allow you.
You could
And
use
so I
the
actually
word
quite like
ecosystem.
ecosystem.
Like we did
Well,
at the-
exactly.
yes, rather than plantation.
Yeah, exactly. Well, I just think that that's absolutely what we should be aiming for. And that's why, indeed, complainants do have to try to think about how they present their case or their evidence in a way that is, yeah, I'm having this problem. I've noticed this gaslighting, this degradation of my access, or whatever it is, you know, and they won't have noticed until it gets quite serious. It might have been happening for some time, or even in a few seconds, it could change the way they have a chance to operate. But as if they put their submissions in, like, this is closed. This is affecting a range of things, not just hypothetically that might come into the market, though that's important, but that genuinely could come into the market, you know. And I'm, as we all are, seems to be very fond of diverse offerings. Therefore, competition on the merits can operate as opposed to competition based on convenience.
It's the duty of competition agencies and competition sealer to be. Where do you stop? Do you think? Obviously, we abandon this axiomatic, formulaic vision of competition embedded in neoclassical economics, where the formulas are the limits and the correctness is the limit. You do some policy making, of course, but still, do you have to make a decision that you facilitate GMO versus organic? So say, is Europe embedded only in organic? Does Europe have to have its own GMO? Big tech? It's all about scale. It's all about computation, and just doing it on the kind of in indie style. It's nice and attractive, but is it a commercial model for big tech?
The reason I don't like choosing who your competitors are, we have this law and it opens up markets, but we don't actually want these competitors. We only want these other ones, is that then regulators are putting themselves in the shoes of consumers and making choices about what those consumers get to have. And I think both that's not their job, and also they're unlikely to be especially good at it, that consumers are much better at choosing what they want. Now, I would be the first to say there has to be a baseline safety and standard. I mean, consumers are not allowed to choose unsafe cars to drive, but once a car is safe, there's a whole range of types and sizes and acceleration and color and interior fit, and that is exactly what markets deliver. So I actually think it is the equation in the sense that it's a theoretical idea. We want to open this marketplace, and there's a standard for that. It's not, I'm going to choose out of this alphabet of customers, I'd like the letter D and M and Q to come in and not the other ones. That's not what a competition authority or a regulator is doing. They're saying, Every safe vehicle is allowed in. Every safe platform that adheres to all our laws is free to start up and enter. That's what we want.
I agree. I agree with that. But there is also, I think that there are two aspects to it that maybe for example, as a regulator, as an authority, we have scarce resources, so we have to do case selection, and this is, I think, typically where you have to think, well, we have two complaints, let's say one by Google on entering the cloud market, and one by, I don't know, a local competitor that is opening another market. And then I think you have to choose. You cannot do both. And here I think that, what is the kind of competition that we want? What is the kind of, how do we want to spend public money? I think there also comes the point, well, there's also private enforcement. If Google really wants to attack Amazon and Microsoft for problems in the cloud market, they have, they have access to courts and lawyers. So a little bit of, I would say market direction or playing referee in a market is inherent to the job that we're doing. But picking winners and losers, I agree not. That's too much. And ultimately, I think this is the second point, is the way we look at, but I realize that this is typically the view of a multifunctional agency like we are. We see competition policy, competition enforcement, not as a goal in itself, but as an instrument to make markets work better. There is a public goal, and there's an ideal set by the government, by the legislator. This is how we think this is the outcome the market should generate. We have several instruments to try to achieve that. One of them is competition enforcement. Then we have regulation. We have informal guidance. We can do all sorts of advocacy, and so our self-image is more that of a sort of a market engineer, in the sense we look at a market, see that there is a problem, and try to fix it, with one of the instruments in our toolbox. And that's, I think, so there also we come a bit closer to not choosing winners and losers, but with a kind of a more active role in the market than, I think, as a traditional competition enforcement agency.
Yeah, the way I think about it is there's three ways that you have to fix markets if you're a government. One is markets that generally work anyway, and that's competition policy, where you stop cartels forming, you stop mergers happening, and so forth. The second one is monopolized markets. Either that's the water that is a utility, or it's Google search and you pass the DMA, and that those are monopolized markets that you regulate to generate outcomes that are more similar to competitive outcomes, okay, and perhaps open them to the future. And then the third, which is under debate in Europe just now, is markets that are just broken. There's a big enough externality that they just don't exist. And then you might need some pro-competitive industrial policy. I might need to build a piece of public infrastructure so that firms can locate next to it. I might need to subsidize R&D because it has such a big spillover that private firms won't do it, and the government has to do it to create an industry. So these kinds of government actions can create whole markets that weren't there before. But if you do that and you make the ones you've got function properly and you regulate the monopolies, then you have this, as you said, Martijn, the vision that is the marketplace that works for society.
I've just had a thought. I mean, the data is extremely important in these markets, obviously, and the platforms have, a large incentive to use this data. They always say the data expires, it's too fast, it's not relevant anymore, etc. Blah blah. Data is still really, really relevant. One area which I'm a bit disappointed with in the UK is the NHS system, which has some of the most confidential data in the world, you can imagine, for the people who use the NHS, the hospitals and that, have obviously signed deals with Palantir. Now, Palantir could crunch the numbers, do the data, do the mining, and come up with extremely interesting things about COVID spread, tuberculosis spread, children's, new diseases that might be coming. A fantastic, lovely analysis. Does it have to be Palantir? Did the UK government have to do that? Could it not have been? And I bet it wasn't an open bid. But even if it wasn't an open bid, in that scenario, we're probably looking at the cheapest provider who's going to be subsidizing it because they get all this fantastic data, which they're going to obviously transmit to the pharmaceutical companies for a price at some point. None of this is rocket science. We've seen this in other jurisdictions that are more open sort of competitive markets, one might think, than the UK. But I mean, for crying out loud, Europe, you don't have to build a new cloud firm or something like that. You're sitting on tons of data. That's an opportunity to say to data providers, data analysts, or whatever, of any size, we think there might be better ways of doing something, which I think this is what digital markets legislation is all about. We happen to believe that things can be better, right? Others don't. They think our system's the most convenient, we're making a lot of money off it, shut up, leave us alone. And fine, we'll fight in court. But I think there's a range of areas where competition authorities can help advise, as they usually do, much more powerful government departments, about perhaps what's best way to identify the cool things that data can reveal, as opposed to just shipping it off in some deal where I have to spend 7 different types of post mail to say, I don't want to be part of this Palantir test, right? And to forget dark patterns, I have to actually lick a stamp. Or first world problems. But I mean, that could have been designed better, there's friends of mine like Rory Catherine-Jones and others from the BBC who say this is going to be fantastic. It's going to change healthcare around the world. Great. Does it have to be going to one massive firm like that? Really, is that the way to do it?
And also, the UK is a bit short of money, so it'd be nice if some of that were flowing back.
Yeah, absolutely, because it's just going to be taken out. Absolutely, good point. Sorry, Aldous, I digress.
No, that's absolutely, that indicates and illustrates very well the problems which we will have to confront if we decide to do it in a public way. And so I wanted maybe to ask you, moving to the end to the conversation, there is more and more conversations about making it quasi-public utility, either existing designated gatekeepers or building something pan-European, or maybe I don't know how it will be done. Is it do we have sufficient skills and knowledge? Are they even obtainable, or do you have sufficient even instruments? If you do it, does it have to be done in a more authoritarian fashion? Because we don't have any good examples of doing it in a public, it's either or there are some hybrid models which would combine the most from one jurisdiction and some elements from others.
But Fiona said this, for example, you don't want a new cloud company built by bureaucrats or something like that. But there are steps you could take, or data you could release, or intermediate stages that you could put something up and say, right, now let's compete for that. And so that's why I think all of this rhetoric about we're going to build our own, Silicon Valley is nonsense. Yeah. The issue is that it can develop. If government would release certain things or provide certain things, then the market might build it. They will come. They might provide some actual competition.
I also think it's a bit funny to say that a corporation is American. I mean, I know why people do that, but if you thought about who owns the shares of Google, they're spread all over the world. Look at who works for Google, also spread all over the world. Look at the top executives of Google. Did they start out life as Americans? Most of them, not really. So in what sense are these firms American? I think that's a little bit of a philosophical existential question, but it matters when you decide we're going to build a European platform. Well, what does that mean exactly? And I think maybe the best answer is what Philip said, which is, well, we're going to take NHS data. That's going to be a core of a data firm. And that data firm is going to be a public-private partnership, or somebody gets to invest, but the government retains some ownership or something. I don't know exactly how you would structure it, but that would certainly attract investment and people and so forth. And if it was NHS data, that would make it be a UK company, I guess.
All right. Let me then ask you about your feeling of the first milestone of the DMA has been already passed. We see designation, how many undertakings have been designated, how many corporate form services. We see compliance summaries of compliance reports. We see some non-compliance investigations being opened. Is it the reality which would you expect, let's say, a few years ago? Are we moving in the right direction? Are there some systemic pitfalls which require immediate or quick intervention and adjustments? Martijn, let's start with you.
Yeah, I would ask for a little constraint in now designing new things and ask for more policy instruments or other instruments. Let's wait a couple more years before we draw any conclusions whether this is working or not. I think that is the most important thing, I would say. Enforcement and compliance take time. I mean, everyone who argued that the DMA would change things overnight, it was totally naive. That it will take a number of years before we are able to draw a conclusion whether it was a success or not. And until that time, I would say, well, let's hold our horses and see what is going on. I think going back to your earlier question, which is politically, which I understand is difficult here, and it also ties in with the argument, with the American companies, and I fully agree with you, Fiona, is that what's American about these companies. I think there is, in this geopolitical world, there is a feeling of extreme vulnerability, particularly in Europe, on what are our trusted allies going to do, and will they use political leverage in order to influence Europeans. So I think that the world has changed dramatically over the past 5 to 10 years, in the sense that I think particularly from Europe's point of view, is that well, we have to kind of reconsider whether we are as sovereign as we want to be, and that I think is a totally different layer. So I have some sympathy for the political argument, is that can we protect our citizens sufficiently if we're so dependent on American companies that, whatever you want to call them, are under more direct influence from a US executive than a European company.
That makes lots of sense. Let me reply to your last question, Olive. I would say, while I agree completely with Martijn that we have to wait a bit, let's recall that an antitrust case in Europe takes 7 years on average, I think I heard at one point, and the point of the DMA is to be quicker than that. So, of course, the first cases at the DMA have to be appealed all the way up so that we have courts telling us what this law actually means. But after that, it should be more brisk. So if it isn't more brisk, then it is going to need some adjustment going forward. So that's one thing, but I'm cautiously optimistic that it will be a lot quicker. And then the second thing, I think there is an existential conflict happening right now, which is at least one gatekeeper, Apple, essentially saying, no, we are not going to comply. And that is going to have to be resolved by the courts. I mean, are laws in Europe laws, or are they suggestions? And if they're suggestions, then the DMA is not an effective regulator because people won't obey it. So there's going to have to be some decisions in the fairly near future about whether compliance is in fact required. And I think that's a bit deep and existential, but I'm also cautiously optimistic that it will come out correctly.
Yeah, I agree. Both of the thing to do now, obviously, while not changing the massive regulatory environment that we've just successfully legislated for, amid amazing distractions with COVID, with the UK Brexit, etc., like that, is to let it bed down. And one of the ways, well, 3 of the ways I would say is bed down is guidance as soon as you can. issue papers. These are our thoughts about this from this market study we've done, that kind of thing. Engagement, which we've talked about already, with as many sides as you can related to the commercial problem at hand. Engagement with the regulators who will have different policy interests like privacy, etc. And finally, throughout it all, transparency. So that's why the ECN DMA event I thought was brilliant. I didn't get to attend in person, but it was one of these things where I thought, wow, that's fast. I've heard a lot of European Commission officials trotted out saying lots of great things, but it's a bit of a black box, really, whether it's the ECN or the European Commission necessarily. And I think authorities that can come out and say, look, we're learning too. As opposed to we know the rules and that's that. They know the rules, they got them. But the thing is, the rules might have been adjusted a little bit during the parliamentary processes in any jurisdiction. But that guides, this is how we're thinking, and this is what the old Competition Commission used to do in the UK: is issue papers and not just speeches, just papers. These are our thoughts. This is where it's going, and have another event, that kind of thing. And also, just on a large P political point. I mean, a month and a half ago, Rishi Sunak, UK, Bletchley Park, we're never going to AI regulate. We don't do any regulation of AI. A few weeks later, new government, one of the first bits of legislation in the UK at the King's Speech will be AI regulation. These things change. Let's just hope that they've engaged as much as that as the competition authorities and the digital people have as well.
And this leads us perfectly to the last question, the traditional question: recommendations to those who start in the process and they have many competitive advantages because of age and engagement with technology. They are much more savvy, much more energetic and enthusiastic. They lack some knowledge, I imagine, a lot. What would be your recommendation? I'm asking you for the second time, Martijn, and Philip. I asked you for the first time, Fiona. But let us start with you, Martijn. How would you tailor their career development?
Be brave. I think if that's I think that's the most important part, is that in this world where there is a lot of insecurity around it, I also see in young people that started at the agency is that they are more afraid to lose what they have, and are less brave academically, as an employee. I don't know about their personal lives, but I think that, and that's also something that we as employers should provide, is sort of basic security, so that people can develop freely into their professional careers. So be brave on the one hand, and on the other hand, a call on employers, but also university to give students, young academics, support and a sort of security. I think that's what we need now more than maybe 5 to 10 years ago.
I'm sorry that you asked me a question. I didn't answer it. Your questions are always some massive, complicated ecosystem, all right? Can't you just have a plantation of questions? Just Philip, yes or no? You, yes or no? No, I'm teasing. No, but I mean, I teach, obviously, and I see students mucking around on TikTok on their phones, and they shouldn't in my lectures because they're missing gold. But anyway, but the point I'm making is, students, young professionals, young authority officials, etc., are at that time of their career when they're actually interested in stuff. And if they're not, and they just want to do this, then fine, off you go, work at McDonald's or whatever. But if you're actually interested in this stuff is really interesting, and it's difficult. And that's why I find it interesting. It's difficult. I've always said to my students, make sure that what you're doing, we do this because it's hard, but also try to have some fun, right? Now it's not that fun at 2 a.m. at a law firm with a filing deadline at 8, and that kind of thing is not fun, right? But you're remunerated accordingly. On the other hand, it's interesting. Part of it will have been interesting. It'll give you some skills. So I would just say to the young people coming in, this is going to be hard. All right. But if you're attracted to that, to challenges, there are other areas of law, I think, and even frankly, competition law, where you can get very excited about it at an academic level, and you get to see the practice of it. It's just monkeys passing paper around on a multi-jurisdictional filing, in all respect, to former lawyers like me and Martin. But, and so this is something that's really interesting, really important as human issues. You can actually see things on your phone happening. Never happened before. Salmon farm mergers, I worked on those. They're disgusting, horrible. Should never have farmed salmon. Don't eat it. Right? But I didn't know about that until I worked on it. And that's the thing. This is an opportunity for the young people to work on these cases that are so important, and to see how different issues are balanced within an authority, and see how careful they are. No authority is shooting with a pistol at, at anything that happens. There's deep consideration of what the intervention should be. And I think that's something that in this area, at least, they would learn a lot more than if they were to go to tax law necessarily, or some other area. And of course, by saying competition law, I include economics, Fiona.
Yeah, I agree with that. I think that competition is intellectually challenging. And if I look at the lawyers that I work with on consulting cases, they are a bit more what we would call pointy-headed academic people than your typical lawyer, because I think they're interested in these ideas. So that is something that law students should think about. But I also really like it as a field because you're melding the law and the economics. And that is a real skill, and knowing how to do that takes some effort and work, but it's quite fun. And advice I would give to everybody, whether regulators or on the outside, is you really want to use the market to your advantage. I mean, trying to fight the market as a regulator you're going to lose. It's like water flows downhill. I mean, it's just very difficult to make it turn around, but you can channel it. So you need to think creatively about how to solve your problem using the market itself to help you, because then you have a chance of being successful. You're not trying to make the water go uphill. And that intellectual exercise is really quite fun, I think.
Absolutely. Martijn Snoep, Fiona Scott-Morton, Philip Marsden, thank you very much indeed for this conversation.
Thank you.
You.
Pleasure.